With that, I'm going to sit down after I introduce your speaker for the day. He is Robert Musanti, the nation's foremost teacher of deposition cross-examination. He has taught the logic essential to taking great adverse depositions of fact, witnesses, and experts to more than 45,000. He has made in-house presentations to attorneys general of 11 states and to the partners and associates of 80-plus law firms and 80-plus CLE organizations. A former prosecutor and civil trial attorney, Robert also taught civil trial advocacy at Boalt Law School in Berkeley, California. With that, Robert, I turn the day over to you.
Thank you, Larry. 1, 2, 3, 4. A little bit lower, I got some echo. Litigators, welcome to a seminar. More accurately, far more accurately, welcome to an argument. I'm going to be making an argument to you all day long. Now, let me say it again, I love the subject of cross-examination. I loved doing it a long, long time ago, and I very much love teaching it. So I have a passion for it. I hope that passion is not off-putting. Sometimes you're going to feel as though I'm making an argument at you rather than to you. Apologies in advance. An argument, as I define it today, is a group of statements, one of which, proponent claims, logically flows from the others. I'm going to be making about 200 arguments to you today. Now, I'm going to be right about every damn one. And you rightly say, we'll be the judges of that, Musanti. Yeah, there's an eval form. If you identify I'm wrong about any single argument, oh, please write it down. Oh, please come and speak to me. Oh, please send me an email at musanti@killerdepot.com. You'll get an explanation, apology, or clarification. Please, today is a matter of reasoning. I do not ask you to trust me on anything important. My obligation is to set forth transparently my reasoning that I say supports a conclusion, and then you guys, both genders all day, will make your decision as to what is sound and what isn't sound. So don't trust me on the important stuff. I ask you to trust that when I talk about some case or a person, I've done my intellectually honest best to be accurate, but indeed I may well be wrong about something. So with regard to those witnesses, if you see an error, you see a double standard, you see faulty reasoning, oh, please let me know about it. All 200 of the arguments are guaranteed to be tremendously entertaining to me. I'm hoping they'll at least occasionally be interesting to you. I love teaching this seminar. I chose examples I was interested in, and I followed a piece of advice that I gave for 16 years at law school, saying to law students doing trial practice, when you're dealing or in the area of opening statement, the directs, the crosses, and the final argument, look for ways to show and tell because it's better than tell alone. And following that advice, you'll decide how well for instance, when I mention a term of art in this seminar, I've identified as word hawking, the ever so keen attention out of the words that come out of your mouth in a cue, a question. The subject, the verb, the entire verb phrase, and the time period. And then word hawking what comes back the other way. Is there a match in the answer? For me, that's word hawking, and more than a few times you'll then see this picture. If you say that's pretty unsubtle, Musanti. I hope all of the teaching points throughout the day are pretty damn unsubtle. I'm in teaching mode. I want to make it clear to everybody, always entertaining to me, and maybe occasionally entertaining or at least interesting to you guys. So, litigators, welcome to the first argument in the seminar. Remember, take nothing on faith, scrutinize all I say. Here is a very bedrock basic notion. If this were a different discipline and I were a football coach, I might well be holding up a football and saying, gentlemen or gentlewomen, this is a football. That's how basic we're going to get so that everybody in the room understands what should come next. You guys are litigators. I used to be, no longer. I'm a teacher. At least I hope you think I am by the end of the day. You litigators now, I litigator before, designed, crafted, and performed a something, the same something that differentiated the legal profession from every other, litigation that is, which you designed was the best case theory, defined as the most favorable, credible application of the law to the most favorable, credible, and appealing interpretation of the facts. My trier of fact is that way all day long. I tried 50-plus jury trials, always to 12 jurors. For some of you, that's a wow number. But if you were ever a baby DA like I was, doing drunk driving cases for 3 years and some other cases, it's not difficult to get to that number, not at all. What you dare not do, I'm having in mind 12 jurors, what you dare not do is to stand before those triers of fact and try to sell them bullshit on issue number 1. I use the word bullshit in all 8 seminars I teach. Here's what it means. A claim so implausible that the advocate on the other side can effectively argue, don't know convincingly, can effectively argue, the claim should be viewed as an attempt to deceive. You dare not try to sell bullshit to the jury on issue number 1 without running the grave risk you may well undermine your credibility regarding issues 2, 3, and 4. There is only so far you can ask them to stretch interpretation of law to application of facts until you break the bond of trust you hope you have with that trier of fact. You perform the case theory in a courtroom, jury trial or court trial. You are designing a case theory from the moment a file hits your desk until it is gone. You are, in my lingo, crafting a case theory in all the pre-trial stuff. And I think I have listed all areas of pre-trial. No one's ever suggested there is one I miss. I take off depositions for the moment. Put that aside. What these share in common is an extraordinary advantage vis-a-vis depositions. That extraordinary advantage is time. Someone says you gotta get out a set of interrogs. They're not saying you only got 30 minutes, otherwise something bad happens in the case. Hell no, it doesn't happen that way. You have time to think, you have time to develop, you have time to revise, you have time to consult. But time is calculated in a vastly different way in a deposition. For every single hour of deposition taking you engage in, no hyperbole, every single hour, you are making hundreds of now decisions. Do I ask this question here? Do I wait till later? If I ask it now, should I use a document? Should I use the document, put it out there before the question or after the question? Someone made an objection. Is it any damn good? Do I care? Words came back in response to a question. Words came back, yes, in response to a question. Was it an answer? Do I follow up with a non-leading or a leading question? Individually, in isolation, any one of those questions, all of us would rightly say, no big deal, no big deal, no big deal. But you add up the cumulative value of all the hundreds of decisions you make every single hour of a deposition to all of the other hours, and you have one hell of a big deal. Because it is principally, qualifying adverb, the quality of the depositions that makes an enormous impact on the settlement or verdict of every case. There's something grievously inaccurate about that slide. That's how big the word enormous should be. Oh yeah, the witness from God, or you get some bombshell document, or there's a change in the law. Maybe you're bright enough to have figured out what the law should be, how it got misinterpreted by everyone else. You file your motion, and you win the case because of your great legal insight. But by and large, over your litigation career, mine and everyone else's, it was the quality of the competing depositions that more than anything else determined the outcome of that case, whether settlement or trial. Seminars, thesis, argument. Taking a great adverse deposition is an intellectually rigorous discipline. And the invocation of the word discipline means it's got rules that apply in every deposition, in every case, for the rest of time. Rules that your law schools and your law firms should have taught you long before now. I'm going to take a wild guess. Neither your law schools nor your law firms taught you what I will teach you today. I have, and when I tell you something about a teaching experience, there will be zero embellishment. I ask you to trust. I am striving to be honest. I've taught in-house 80 law firms. There is not a single law firm in this country of which I am aware, or a single law school of which I am aware, there's a qualifier, that teaches the stuff I will teach you today. And shame on all of the law schools and law firms for not offering it to law students who are going to go on their way to litigation, and litigation law firms who are obviously deeply involved in litigation. Section 2, page 4. I like my cheesy sound effects. Oh, I was hoping that would be a little bit louder, but that's okay. Battleships is a label. I give a concept, not a complicated one. Long ago and far away before the advent of computer games, sometimes kids, including me, would play half hour, whatever it was, with my buddy across the street, the game of Battleships. We thought it was fun way back then. So on our respective grids, we had 15 numbers across the top, 15 letters down the side, 225 squares, and then we would secretly set forth somewhere on that big ocean the ships we agreed we'd have, battleships, aircraft carriers, submarines, etc. And then what we would do, again, it seemed like fun back then, we would take turns trying to guess where the other guy had placed his ships. So I say to my friend, you got anything in square C2? The rules were, if there was something there, he had to tell me. So he says hit. And he had to tell me what kind of ship I hit. He says battleship. We agreed a battleship would have 3 pieces. I just hit 1. One, at least, of the other 2 pieces must be touching square C2. What my reasonably bright friend did not do in the game at that moment is turn around his grid and show me where the other pieces were. No fool was he. He kept his big mouth shut, and then what I had to do was to try to guess where the other pieces were, and eventually, if he didn't get all of my fleet, I would find where the battleship was. You say relevance, Musanti. In every single deposition where there's a minimally competent attorney on the other side representing the deponent. I said every single. I do not use categoricals loosely. Every minimally competent opposing attorney has said something like this to their client who's going to be deposed. Understand, Charlie, the more words you speak on this record, the greater chance there is that one of those words is going to come along later and bite you and me in the ass. Do you understand? If Musanti asks you in this deposition today, have you been to the moon? You say no, and then keep your big mouth shut. Do not say no, you're afraid of heights. Do not commit us in this deposition to the sole reason why you did not go to the moon is you're afraid of heights. If why you didn't go to the moon becomes relevant later, leave us a blank slate into which we can introduce the truth or perhaps something other than the truth. Do you understand? Witness nods and, of course, then violates that rule multiple times in a deposition. It happens. But they've been told to give no more information, just like my buddy. So every practice has its own set of battleship questions. After I was a baby DA for 3 years, though hopefully no longer a baby at the end of a year and a half and 20 or so drunk driving cases, after I was a DA, I did employment and personal injury, principally. Those 2 areas of practice have a different set of battleship questions. You're not asking in employment cases, were you driving and drinking coffee, and were you late? Was your car in good working order? No, that set of battleship questions belongs in a PI case. Every kind of area of practice, a kind of litigation, has its own set of battleship questions. And those battleship questions are indispensable. You have to use these questioning words to cast the widest discovery net in your very best attempt to get the adverse deponent to give you a response to every square on that grid, to tell you an answer, true or untrue, about their first or second in information, or to tell you that they don't know the answer to the question, or they don't remember. You got to do the battleship question. You got to get adverse deponent story. We've got an abbreviation, AD, adverse deponent. He, she wants us to lose the case. 3 abbreviations I use throughout the slides. CE is you and me all day long. We're the cross-examiner. OA, the opposing attorney. Why the cuteness in the abbreviations? Because I could make the font in the other letters larger if I didn't have to write adverse deponent. Battleships is not a tough subject to master. I have said since 1993, without anyone even attempting a contradiction, the following. If you conduct 25 of the same kind of case depositions, 25 car accident cases, 25 employment discrimination cases, you've done the ancillary work, 1 case went to trial, your second chair, 2 cases went to mediation, you've defended the depositions. By the time you've done 25 same kind of case depositions, you've pretty much learned the set of battleship questions that need to be asked. You're not getting some great, thank you, Patrick. No great brownie stickers for you. You're reasonably bright. I am. We can learn each other's set of battleship questions. Section 3. The rules. The 4 nearly everybody in the country agrees rules. You don't need to write them down. I've done it for you. I give you briefly proof that these are 4 nearly everybody agrees rules in the country. I used to take hands at this spot in the seminar. I'd set out the rules and I'd say to the audience, to make it quick, is there anyone in the audience who disagrees with any one of the rules? No explanation. We don't have any time for that. Just tell me the number. They raised their hands. And the way it turned out, for well over 15,000 lawyers I surveyed, is 0.5% disagreed with all 4 rules. So the deposition rules that very few disagreed with then were these. Subject by subject, predominantly, notice the qualifying adverb. I underlined it, I put it in red. Predominantly ask non-leading questions. A deposition examination is quite unlike a trial cross-examination. Oh, there'll be some places in a depo to ask a leading question, but your principal default tool must be wide discovery net, who, what, when, where, why, how. Second rule, when you get a good answer, leave the damn thing alone. Don't give the 2 bad guys. What do you mean 2 bad guys, Musanti? The adverse deponent wants you to lose the case. Let's just make him the opposing party all day long. His lawyer wants you to lose the case. So I'm not saying morally, but legally, they're the bad guys. They're against us. Don't give them a second shot at the question if you like the answer you got the first time. Customarily save impeachment evidence for surprise at trial. The way this rule is applied around the country, in my experience, qualifying phrase, is far stronger than customarily. What newbies are taught around this country is to almost always save impeachment for surprise at trial. But when I offered the rule, asking who agrees with it, I wanted to arrive at consensus, so I used the milder adverb. And if disclosure of the impeachment occurs at the depo inadvertently or otherwise, rule number 4 flows therefrom. This is the way it's applied around the country, but again, I offered it more mildly. Customarily, conceal the case theory argument that is based on that impeachment evidence until trial. I offer you today precious little authority for any proposition I proffer. What the vast amount today is me setting forth my reasoning and you making a judgment. Do we agree or disagree? But here, invocation of authority for Rules 3 and Rules 4. I offer 2 authorities. The best and then one a touch weaker. The best authority. It's the guy who owns the center chair in the pantheon of civil litigators in this country. Period. David Boies is the most lauded civil litigator in this country. Second place ain't even close. I didn't say he was the best. We don't have metrics for that. The most lauded. Among the many things said about him, David Boies, the most brilliant litigator of his generation, best trial lawyer in America. I'll take a sip, you read. Wow. The Michael Jordan of the courtroom, and it goes on and on. You do the Google on both internets, and you will not have enough time to read all the encomia set forth on those internets. I am a huge fan. You did not hear sarcasm because it wasn't there. I am a huge fan of David Boies. This guy multitasks on billion-dollar cases. He wrote this book in 2004. A couple months later, I bought it, devoured it in a month, month and a half, whatever. It's a holy cow practice this guy had. In this book, the longest segment is about his case where he represented the federal government against Microsoft in an antitrust case. The longest passage, a chapter, is about what he calls his conversations with Bill Gates. What he means is his deposition of Bill Gates that lasted 3 days. I am going to show you representative clips of that deposition. It was offered, some federal rule of civil procedure. If it got shown at the trial, it had to be offered to the public. I saw it, I bought it. Apologies in advance. The tape given to me by the feds is not altogether bright. You'll be able to hear the words. That's what's most important. But it's not a very pretty sight. They held the deposition in a room without any windows. So far as I can tell, 2 tallow candles somewhere off in a corner are the only illumination for this deposition. So that deposition taken by David Boies was highly praised as well. Here are just from 2 different sources. The one on the right is the National Law Journal. Extraordinary things said about the depot. It's not an advertisement. I wouldn't in any way advise you guys to go see the seminar I call The Anatomy of a Superstar Deposition. It has the same teaching points as this one, but the examples are exclusively, lots more examples than you will see, of that deposition. So here's what you need to know about the Microsoft case. I'm going to abbreviate, and therefore I'm necessarily going to distort, but not in a way, in an intellectually dishonest way. I'm doing my best. The United States government was extremely unhappy with the way Microsoft was interacting in the marketplace vis-a-vis this little startup company, or rather new, Netscape. Pesky Netscape developed a browser they called the Navigator. Government's case theory is Microsoft breached the antitrust laws, none of which I understand, to try to crush little Netscape. So we, the government, are going to sue Microsoft for antitrust violation. The federal government and many states joined in as plaintiffs. A core fact at the time the litigation was going on is Microsoft had a chokehold on the market regarding operating systems for PC computers. I'm an Apple. I would not know how to do Windows, DOS, read manuals. Glad I went a different direction. But a world of people that wanted to use all the fancy applications that Windows would offer, that were available to PC, basically had to use Windows. Why? Because all the application makers in the world had to salute Microsoft to make sure their little application worked with Microsoft so they could have this gigantic PC market. What terrified, that's not hyperbole, what terrified Microsoft is along comes this browser, which Microsoft recognized the browser could sit on top of an operating system. The browser could be a platform into which applications were plugged, meaning that someone walks into a store, they could say, hell, just give me any operating system, give me the cheapest. I have Navigator, applications will plug into that. Microsoft then could no longer charge the princely sum they were charging for its operating system. Microsoft was terrified that their operating system would be turned into a toaster. Huh? You walk into a store, want to buy a couple that's going to get married next week. They really love toast in the morning. I need to get a toaster that'll toast raisin bread. And the salesperson says, all our toasters on the shelf will toast raisin bread, rye bread, wheat bread, no problem. You don't have to get a specialty raisin bread toaster. Microsoft was terrified that the price of their operating system would plummet. So, clip, again, 2 tallow candles illuminating everything here. Going to show you a clip. I'm going to have the words written down that are spoken, so you don't need to be scurrying. Boys wants to prove that learning the sources of Netscape's revenue was a top priority for Microsoft, including, of course, its CEO, Bill Gates. So those sources could be choked off, so that Microsoft could go to those places where Netscape was getting its revenue, and Microsoft could share its terrifying finger and say, you better wed Internet Explorer, you better ditch Netscape, otherwise bad stuff's going to happen to you.
Did you make any effort in 1996 to find out what Netscape's revenues actually were?
Personally?
Either personally or through some of the many employees of Microsoft.
Well, I'm sure there were people at Microsoft who looked at Netscape's revenues during that year.
Did they communicate with you as to what those revenues were at all?
Among the thousands and thousands of email messages I get, I'm sure there were some that had, for certain periods of time, information about that.
Did you request any information concerning Netscape's revenues in 1996?
I'm sure I was in meetings where the information was presented, but I don't think I was the one who specifically asked for the presentation.
Whether you specifically asked for a presentation in a meeting or not, did you ask people to provide you with information concerning Netscape's revenues in 1996?
I may have asked some questions about their revenue.
Do you recall doing that, sir?
No.
I'll return to that Q&A, but first want to go to David Boyce's book. Most depositions are designed to prepare for trial, he wrote, and you try to develop the building blocks you'll use then at trial rather than explicitly combining those blocks to establish your case at the deposition itself. What Dave is essentially saying is this: hey, litigators, do the best you can to keep the elements of your attack, the elements of your arguments scattered, as opposed to gathering them in a neat pile with a sign on them, because what you're striving to do is to keep the other side uninformed how you intend to attack them at trial. Very same hymn, very different case, background told very quickly, I promise. In the O.J. Simpson civil case, he was acquitted, of course, in the criminal case. Along comes Daniel Petrocelli trying O.J. Simpson for wrongful death, representing the plaintiffs. Petrocelli, was involved in a 9-day civil deposition of O.J. Simpson. He wrote, Petrocelli and his co-author did, we plaintiffs' attorneys chose not to confront Simpson with his many contradictory statements to the 2 chief homicide detectives. When Simpson flew back the afternoon after the murders, he waived Fifth Amendment, he talked to the homicide cops, gave a 30-plus minute interview. Confrontation at Simpson's civil deposition was not our goal. We were obtaining the raw materials, laying the groundwork to build our case for the jury later at trial. When it counted, the emphasis is mine, the words are Petrocelli's. Petrocelli and Boyce are singing the same tune. Do your best to save impeachment for surprise at trial when it counts. Now, with regard to these 4 rules and these 2 passages, this is Deposition 101 all across this country. If I don't say it each time, remember, it's Deposition 101 so far as I'm aware. And if there's anyone in the country who has a greater database than I do about what lawyers are taught about depositions, I don't know who that person is. This seminar argues those 4 rules and those 2 passages are flat out wrong. Abysmally wrong. Abysmally ignorant. Seminar's thesis, part 2. The vast majority of litigators, even those who are Pantheon worthy, and there's absolutely no doubt Dave owns the center chair, end of story. Petruccelli may well be in the Pantheon. Don't have a basis to say he is or he ain't. They take mediocre adverse depositions their entire careers. David Poyce took a pathetically mediocre deposition in the Microsoft case. I would have been ever so embarrassed to take a deposition of that quality. Holy cow. You haven't had a trial since 1996, Musanti. You've not taken a deposition since 2001. You've been inactive in the great state of California ever since that time, haven't you? Yes. And yet you're saying that Boyce took a pathetically mediocre deposition in the Microsoft? Flat out yes. Bet the house on it. Anyone who praised that deposition either didn't read it or they had their head up a very dark place. Point. I will teach every one of you to take a vastly better deposition than Boyce did in the Microsoft case. It ain't hard to do. Mediocre in comparison to the deposition I will teach you how to take. I have critiqued those 6 questions and 6 responses on those pages. I am not going to go there. I've written out all the remarks. It took that many pages to identify all the flaws in but 6 questions. I ask you to trust me on something. I did not go through 682 pages of a deposition and cherry pick the 3 or 4 or 5 passages that I could rip the hell out of and then show them to you so I could pretend to say, look, I can take a better deposition than he did. I teach a full-day seminar. I take it around the country. I show a lot of that deposition. I am not afeard of anybody grabbing any passage in 682 pages and say, you didn't tell them about this great nugget, did you? There are no great nuggets there, period. It is obvious to me that brilliant, no sarcasm, David Boyce never learned the eminently learnable discipline of deposition cross-examination, which is what today is about. Eminently learnable. Nothing I say today, nothing will rise to the level of the calculus. I never even got past 2nd year algebra. Nothing is going to cause you guys to scratch your head and say, I'll never get that. Damn, that is subtle. Damn, that's tricky. Damn, that's hard to remember. Everything I say to you today will be at the level of Euclidean geometry, which I and probably you studied 1st, 2nd year in high school. There'll be no